Hello everyone, and a very warm welcome to this ICAS webinar, Employment Law and Immigration Law Update for Accountants. For those that don't know me, my name is David Mingus. I'm Director of Practice here at ICAS, and it's my great pleasure to be the host of your webinar today. So if you're in any way involved with business, then it's virtually impossible to ignore the subject of employees. The likelihood is that you'll either act as an employer in your own business, advise businesses who are employers, or will be an employee yourself. Or indeed, sometimes you're a combination of all three. As a result, it's important to understand the law and best practices around employment, and failure to do so can result in significant difficulties arising and can be costly, not only in terms of financial cost, but also reputational damage. In many businesses, employees remain the biggest or at least a very significant cost to the business, and recruiting and training costs often add to that. I think it was Richard Branson, founder of the Virgin Group, that once said, "Clients do not come first, employees come first." If you take care of your employees, they will take care of the clients. One of the most frequent conversations that we in the practice support team at ICAS have with members is about the difficulties firms have in attracting and retaining talent in what is a tight and challenging market. The normal and traditional local marketplace may no longer be sufficient to meet business needs. So wherever you are in your business, being up to date on employment issues is a key success factor. Earlier this year, a raft of new employment and immigration legislation was introduced, and of course, case law and employment tribunal decisions continue to impact in this evolving landscape. So over the next 55 minutes or so, we'll be looking to provide some clarity on the recent legislative changes, unpack these recent developments, look at the measures you need to put in place to be compliant, and of course, consider recent decisions from courts and employment tribunals. To help explain and understand some of these matters, we're joined today by employment law and immigration law specialist from Anderson Strathern. And I'm delighted to welcome back Don Dixon, who will be well known to many of you of these ICAS webinars. Don is a partner in the employment team with over 2 decades of experience at the highest level in private practice. Don has a strong experience across a number of sectors and is passionate about CSR initiatives, and also sits on the board as co-chair of the homeless charity Rowan Alba. As well as a specialist employment lawyer, Don is also a skilled and accredited mediator. We're also delighted to be joined by Mark Templeton, who is Head of Immigration at the Anderson Strathern Employment, Immigration and Pensions team, and has extensive knowledge and experience in immigration law. He acts for public sector organisations and private individuals, helping them navigate the UK's complex immigration system. Mark acts for clients to ensure their compliance with right to work laws for their employees, as well as to obtain sponsor licenses and visas to employ overseas workers. So I'm delighted to welcome both of you to today's webinar. Before we begin and before I hand across to both of them, just a few housekeeping matters to remind you of. You can, of course, submit questions at any time through the Q&A facility, which is accessed at the top of your screen. Questions can be submitted anonymously. You can also join in the conversation through the chat box, which is also accessed at the top of the screen, and this allows you to comment or discuss with fellow attendees on matters covered by this webinar. I should say that some of these facilities may not be available to you depending upon your own organisation settings. It's not stuff that we control at our side, so if you're not able to access them, that is due to your own organisation settings. We are, of course, able to record this webinar, and we'll make that available for on-demand viewing afterwards in case you want to refer back to it or share it with others. And the slides for today will also be available on the events page of the ICAS website under the events listing. So we do look forward to receiving your questions throughout the course of the webinar, and we'll try and get to those, as many of those as possible, once we get to the Q&A section. So I do know that Don and Mark has a huge amount to get through, so I'll pass straight across to Don to get into the detail of today's webinar. Don, over to you.
Oh, thank you, David, and good morning, everyone. It's lovely to be here from a very gloomy Carstorphine Hill this morning. What I'll be looking at between now and approximately 11:25 is our employment law update before I'll hand over to Mark around the 20-minute mark for him to update you on immigration matters. I'm going to be looking at some current headlines, which you will likely have noticed, some changes to case law and some recent updates from a legislative perspective in employment law, just to check that we're all up to speed and aware of those changes that have in particular come down the line in April 2024. I then want to leave a bit of my 20 minutes to look at what's coming up towards the later end of 2024. And in particular, I'll look at some really significant and quite far-reaching changes in relation to the laws on protection from sexual harassment. We'll all know this has been a developing area of the law since about 2017, some scandals in Westminster, Hollywood and the Me Too movement, but employers in the UK are going to have some particularly challenging issues to grapple with in relation to the shift in law in that area from October this year. So I'll try and leave at least a few minutes of my session, 5 minutes at the end, to cover those changes, because they will be significant for all employers in the UK. So looking at the first topic I'm going to cover this morning, just some recent headlines in the news, just to kick us off this morning. So we saw the headline on the 2nd of May from Goldman Sachs that they had become the first to remove the cap on bankers' bonuses following changes to UK employment law introduced last year. And as you will imagine, Goldman Sachs discussed this decision in relation to the provision of flexibility in their structures and their remuneration structure, and an ability to pay for performance. However, this decision was met by the Trade Union Congress as, I think it was, an insult to the working people, was how this headline was met. And there'll be interesting developments in relation to bankers' bonuses and other businesses following suit. We also, straying into Mark's area, saw that the withdrawal of some job offers by HSBC and Deloitte on the 15th of May, reported in the press, in relation to foreign graduates from UK universities. This is, according to reports, due to the new skilled worker rules, and Mark will cover these for us this morning, and in particular the skilled worker pay rates, which have changed, and so for those under 26 years of age. And so whilst this decision has, certainly from my perspective, decisions of this type have employment law risks in relation to indirect discrimination where decisions are taken of this type, we may see further decisions of this type in the future. And then finally, I thought I would touch on the John Lewis decision, which was to publish its job interview questions on its website, which 2/3 of a poll on LinkedIn said they saw as a very positive move from a diversity perspective, a neurodiversity perspective, and seems to have been met with positivity in relation to how they choose to recruit. And their view is that that will allow individuals who are applying for jobs with John Lewis to absolutely show their best side and put their best foot forward in interview. And it will be interesting to see if other employers decide to follow suit in the arena of recruitment, which of course is also an area in which discrimination law is extremely important. So we will see if that seeks to improve the arena of discrimination law and enables John Lewis to attract the best workers as per its intention. Looking now to our case law update, so in relation to employment status, as you'll have seen, the government were urged to relook at IR35 following the case of HMRC against RALC, which after 10 years saw this decision being sent back to have a further look at matters from a legal perspective. And in this case, as you'll be aware, the upper tribunal found that the first tier tribunal had erred in law by not properly constructing a hypothetical contract in relation to RALC's terms for each of their engagements, and in failing to apply the employment status tests correctly. And those were the tests in section 49 of the 2003 Act. There was also criticism in relation to the application of mutuality obligation tests in relation to this case, and it has caused quite a degree of concern about the ability to interpret the rules and how we may see this area developing going forward. So there have been a number of articles urging a relook at this matter. And of course, it will be, I suppose, in particular for the individuals concerned, given that we're constructing a hypothetical contract on legal principles so long after the event, quite a difficult position for them to be in. In employment status, there was also the case of Broom against Maritime and Coast Guard Agency, which was about a volunteer for the Coast Guard Agency who claimed they were a Limb B worker under the Employment Rights Act, and therefore as a Limb B worker rather than just a volunteer, they said they had been denied their right to be accompanied under the Employment Rights Act when they were dismissed in a disciplinary hearing. And this was a classic case where what was decided was that the label in the contract, which says it was an agreement for a volunteer only, failed to look at the practical realities of the contract between the parties. The individual was entitled to remuneration for certain activities and on a day-to-day basis fulfilled those tests of a worker rather than somebody who was strictly a volunteer. And as such, the decision was substituted that the individual was a worker and the label of the contract can't be something that can be relied upon. And that's something we see regularly in the employment tribunal, where we have the categories of employee, self-employed and worker. More often than not, in these cases, there's quite lengthy preliminary hearing in relation to status, and this point about the label of a contract, what we call a contract on paper, is not determinative of the position. So further re-emphasis of that point in this case. In relation to discrimination law, we saw in the case of Baldwin against Cleeve School and others, a re-emphasis about the liability of individuals for discrimination claims. So we often see in the press very large awards being made against employers for discrimination. And I often think it's met with interest when I'm training groups of managers, when I remind them that not only can the employer be vicariously liable for acts of discrimination that they perpetrate, they can be financially liable as well. And I have represented individuals on the receiving end of discrimination claims who become extremely distressed when they think, do I have to remortgage my house to meet the liability of a discrimination award where it's against them personally? And this case was a reminder to the employment tribunals that they don't have a wide-reaching discretion to take a decision in relation to whether the award is against the employer or the individuals. And this was a case involving a teacher who brought a claim against both the head teacher and their mentor for two specific acts of discrimination, one attacking their integrity and one was in relation to not having a postgraduate qualification they needed due to ill health and an inquiry having been made inappropriately by that teacher. And a real reminder there that tribunals can err in law in finding that the individuals were not liable where claims have been brought at their door. In the ACOM case, disability discrimination also, we had an individual there who was dismissed, who then reapplied for a role in 2018, citing dyspraxia and making an application to apply for the job orally. Didn't specify that they were having trouble setting a user word and a password, but did say, please can we organise this by email? I would like to apply for a role orally. Please contact me and I will give you my telephone number. We'll have the call in that way. What happened was that the HR department didn't call him. He was then unsuccessful in his application for the job, brought a successful disability discrimination claim there, and a real reminder in recruitment processes for employers to make reasonable adjustments for individuals. In Rentokil against Miller, we also had a reminder about the real duties upon employers in relation to making reasonable adjustments. In this case, we had a pest control technician who was in a physical role, a very physically demanding role, and at a certain point was diagnosed with MS and the role became unviable. He then sought to apply for more of an administration role and a service administration role, and the employer considered matters, looked at his skills, thought some were irrelevant, his Excel skills were lacking, and decided to refuse for him to have that role, which then ultimately made his dismissal in his substantive post, the very physical one, inevitable. And in that case, there was a finding of discrimination on the basis that by the very fact that the employer hadn't looked at a trial period in relation to the other role, they were guilty of discrimination in that case. And then finally, we have the Imoba case, which was a Christian actor who in 2014 posted very public views about homosexuality on social media. She then got the leading role in The Colour Purple on stage, and you may have seen this one in press as the character Celie, and was ultimately dismissed when she refused to retract her comments about homosexuality, given that the character she was about to play was a lesbian in the show, and social media criticism of the show would really have commercially impacted it. She claimed that this was discrimination in relation to her beliefs, and she claimed that she should be awarded a disability compensation as a result of that discrimination. Discrimination compensation on the grounds of her beliefs. And she was unsuccessful in that. What was held here was that the dismissal and the fact that she was not allowed to continue with her contract was actually because of the social media storm and the commercial damage, and nothing to do with the protection she had in relation to her beliefs. Unfair dismissal now. We have a number of decisions in unfair dismissal. The Hilton Foods case looked at where somebody is dismissed because their dismissal is related to an application for parental leave. In this case, the chap in this case, he merely talked about taking leave and emailed about the potential to take leave. And ultimately, when he was dismissed for other reasons, he claimed that there was a link between his dismissal. And this case looked very much at whether he had actually made an application for parental leave that he could link to his dismissal in relation to claiming this form of dismissal. And the EAT in this case said where somebody has sought to claim parental leave, it's in those cases that they can claim detriment in relation to dismissal, and there needs to be a factual inquiry in relation to whether this can be counted as an actual application, and the individual was unsuccessful. In Biolas, we also recently had a case where a cash processor in that case had searched the internet for a clean joke to tell colleagues, and ultimately posted something which appeared quite rightly to the organisation to be potentially racist. He posted a comment that was, "Don't be racist, be like Mario," referring to Super Mario. He talked about Italian plumber created by the Japanese, looked like a Mexican, said, made various comments that were potentially racist and interpreted as such by the organisation. He was ultimately reported for racism and was dismissed. And the tribunal at first instance stated that because of the remorse that he had expressed, because he had not intended this to be racist, he's intended it to be a clean joke to post to colleagues on their new intranet, that this was an unfair dismissal, and his dismissal was not within the band of reasonable responses, quite surprisingly. The EAT said no. They should have concluded that a dismissal by any employer for these grounds would have been within the band of reasonable responses, which is a really significant test in relation to unfair dismissal. And then we had a similar decision in Borg against Neil involving racist comments where individuals were dismissed because of purportedly racist comments. However, when looking at the band of reasonable responses, in this particular case, the comment was made during a race awareness session, and therefore the decision was not within the band of reasonable responses. And in the Charleboux case, we also had a decision there about investigations. A lack of meeting between their employee and the dismissing officer was not fatal to the case, and a fair dismissal could still be made in that case where another individual within the organisation had taken steps to meet with the employee. So we often talk about how important procedures are in employment law. You need to have your investigatory officer, your dismissing officer, and your appeal. Whereas in this case, despite the fact that the dismissing officer themselves had not met with the individual, the fact that other individuals within the organisation had met was held to be okay in that case. In this case here, we had a whistleblowing decision, very similar to the last case, where there had been a separation in individuals dealing with parts of the process. And what that case held was that the decision maker in any dismissal needs to possess a level of awareness about those things that employees ultimately seek to link to their dismissal at a later stage in the process. So we had someone who had made a public interest disclosure of a whistleblowing nature. They then were dismissed for different reasons and sought to connect the disclosure made at an earlier stage to their dismissal. And there does need to be, in this case, it was established a level of awareness regarding the substance of that whistleblowing complaint for an employer to be liable for any dismissal or detriment connected to whistleblowing. And then in Bathgate, we had confirmation that in relation to settlement agreements, these can be used, and we've had an amount of litigation in relation to this, but settlement agreements terminating employment for a certain amount of money, they can be used to settle future claims as long as the types of claims are clearly identified within the settlement agreement, and the objective meaning of the words used in the settlement agreement are very clear. Okay, just a few minutes now on recent legislation. So we've had quite a number of changes in April. We've had the introduction of carers leave on the 6th of April. So individuals who are eligible to take carers leave can now take 1 week unpaid carers leave in any 12-month period. And I know it's not a lot at all. We think 1 week, you know, wow, it's really not much. But it's 1 week of carers leave where individuals want to be absent to provide care or arrange care where they have dependents with long-term care needs. It can be taken as a 1 week block, but it can also be taken in consecutive half days or full days. And the notice to be given is twice the notice of the leave that an individual wants to take, or 3 days. So that's the new right to carers leave, and it is a right to unpaid leave, and it's a day one right. We then have paternity leave changes. So rather than having to take paternity leave as 2 weeks consecutively, it can now be taken in 2 separate blocks of 1 week. It can be taken any time in the 52 weeks after a birth and not 56 days after a birth as previously. And you need to give 28 days notice now of a right to take this leave, as opposed to the 15 weeks before the birth you used to require to take. And you can change the leave dates on 28 days notice. We have the extension of redundancy protection also came in April. So individuals who have this trump card where there is suitable alternative employment on redundancy have had an extension of this trump card. So you will now have your trump card from the point that you notify your employer that you're pregnant up to 18 months after the expected date of birth, or the actual date of birth of your child, which is a significant period, and one in which managers really do need to be briefed, because you can imagine how easy it might be to forget about an individual who has been in this protected position for the whole of the birth plus 18 months after in relation to redundancy. And we've also had the right to pay rolled up holiday pay at 12.07% now for holiday years after the 1st of April 2024, which is in relation to part-year workers or irregular hours workers only. And a number of articles have appeared in relation to this, but it has been widely, very positively received on the basis of that the Harper and Brazil Trust case did not, in relation to holiday pay, have leave in relation to the amount of time worked. Workers were entitled to 5.6 weeks, whether they worked part year or not, whereas from this change and the ability to pay rolled up holiday pay, it will then be the case now that the holiday accrued will be relative to time worked. And flexible working, we have a day one right in relation to flexible working. There is the amendment regulations have come in, and this removes the requirement for employees to set out the impact on the business in writing. They can now make 2 flexible working requests in a 12-month period, and employers have to get to the end of the period now within 2 months rather than 3. Okay, getting to the end of my section, I'll be handing over to Mark soon. I wanted to highlight for you just some recent new guidance that we have in relation to menopause, in relation to AI, and in relation to the Vento bans in discrimination claims. So a lot of good stuff in there to catch up on. And in relation to what's coming up, we have the Statutory Code of Practice on Dismissal and Re-engagement, which you'll have seen lots in the press following the P&O Ferries case about the unfairness that can be in place where dismissal and re-engagement is used to change terms and conditions or on other terminations. And we're expecting these changes in July 2024. There will also be a right to request more predictable contracts for those who find it difficult to plan their lives because of their contractual arrangements from September 2024. And quite significantly, from the 26th of October 2024, there will be changes to sexual harassment laws in the UK. At the moment, there is a really reactive duty on employers to defend, while they have sexual harassment claims, they can defend them on the basis of they've taken all reasonable steps to prevent discrimination before it happens. From October of this year, there will be a proactive preventative duty on employers to avoid sexual harassment, which will require the training of managers, the training of staff, more monitoring, a real impetus on leadership to really lead from the front in relation to sexual harassment. And if employers are found not to have adhered to their duty to prevent sexual harassment, there will be a potential 25% uplift on compensation that they can be found liable to pay at employment tribunals. So a really significant change here. And with statistics showing that 2/3 of young women report experiencing sexual harassment in the workplace, these changes will be felt really significantly by UK employers. And there's a lot of planning for them to do before October of this year. Now, if anybody would like any additional information on any of these areas, it'll be no surprise to you that I can send you a raft of additional information on any of the topics I've covered this morning. And I'll now hand over to my colleague, Mark. Thanks, Mark.
Thank you, Dawn. Listening to all that, I certainly don't envy being either an employment lawyer or an HR professional with the volume of areas to cover. Good morning, everyone. Dawn's passed over to me as the Head of Immigration at Anderson Strathern. I am, as you'll see from the title of the slide, we're going to be discussing the changes to the skilled worker visa for, and specifically with regard to the accountancy sector. I'm always aware when presenting to any sector that there'll be those attending who have a sponsor license, which enables a business or organisation to sponsor skilled workers, but also those attending who will not have a sponsor license. So I'm going to try and cover both categories of attendee, if you like. So the areas I hope to cover are firstly really just to set the base of the overall immigration context in which we operate for employment in the UK. And having dealt with that, that will bring us on to see when a sponsor license is required. I will then go through some of the basic steps of applying for a sponsor license and consider the test that the Home Office apply when they're looking at an application. Then I will move on to discuss the basic rules that apply to sponsor a skilled worker and what we call the general minimum pay. But then that will bring us on to the very topical significant increases to the general minimum pay that took place or came into effect on the 4th of April. And then I'll apply, after I've dealt with that in general, setting out the general framework, I'll apply it specifically to the role of accountant and discuss the various salary scales that apply. I will then, somewhat confusingly, explain to you the general minimum pay, but then when there are instances where when a skilled worker can be paid less than what is called the general minimum. And then I will wrap up by looking at the significance of the changes. So to start with the overall immigration context, since Brexit, the only people in the UK who have an existing right to work include British or Irish nationals, EU nationals and family members who now have status under the EU settlement scheme, and they are EU nationals and family members who were living in the UK before Brexit, being 31st December 2020. And then finally, the final category, which is a broad category, who have a right to work, is any British or Irish national who who has a visa that enables them to live and work in the UK. You will no doubt be familiar with a student visa holder, graduate visa holder, partner visa holder. You could have a refugee who has been granted settlement. There could be a youth mobility scheme. All these various categories of visa holders have a right to work aligned to their visa, albeit to differing degrees. So those are the three broad categories who already have a right to work. The scenario then arises of if an employer wishes to employ someone who does not have a visa, or who would require a visa to continue legally living and working in the UK. And that's what brings us into the territory of needing to apply and obtain a sponsor license. A sponsor license, as you are probably aware, is granted by the Sub-Department of the Home Office, UK Visas and Immigration. Now, the sponsor license system, relevant to your sector, it enables a UK employer to sponsor a person in a skilled worker occupation. The individual must apply for and obtain a skilled worker visa. There is a list of occupations that are considered as skilled and eligible for sponsorship. I refer to this informally as the skilled worker list. There's a link in the slide, and understand these slides should hopefully be shared. And by accessing that link, you see the whole raft of occupations that the government has accepted meet the minimum skill level and that can be sponsored as skilled worker occupations. For each occupation on the list, a minimum salary requirement is specified, and that minimum salary must be paid by the employer to the skilled worker. And it's really quite simple. If an employer is looking at a role within their organisation, they need to find a relevant occupation on the skilled worker list. And if a fit cannot be found, then it's the intended role in the organisation cannot be sponsored. Sometimes helpful in this regard is, or not helpful, depending which way you see it, but the Home Office has a list of jobs not eligible for sponsorship, and they're not considered sufficiently skilled, and they're found in Table 5 of the immigration rules. And that's the immigration rules is essentially the statutory instrument that sets out all the raft of rules, and that can be considered also in a link has been provided. Basic requirements for any organisation applying for a sponsor licence must be a genuine organisation operating lawfully in the UK. It must show it has key personnel in the UK who can manage and be responsible for the licence. At the time of the application, the key personnel must be employees or office holders of the organisation, and they must be sufficiently senior to be responsible for the licence overall and to adequately supervise any sponsor skilled workers who they have in their organisation. Basic national or immigration rules for key personnel must be British or Irish, must have status under the EU settlement scheme, or a permanent right to reside in the UK. In terms of how does an organisation apply, it's essentially an online application. It is requiring information in respect of the organisation, information on why they need to sponsor skilled workers, information on current employees, immigration status of employees, information on the predicted numbers of skilled workers it's intended to sponsor, and the likely or intended roles that wish to sponsor will require to be specified. And then information on the key personnel who will manage the sponsor licence. After that application is submitted online, there's a raft of documents that require to be sent to the Home Office, and they're fairly routine documents in respect of registration with HMRC for PAYE VAT to show you have relevant employer's liability insurance, a business bank account, proof of ownership of premises, etc. The tests to be met when an application is submitted, here's what the Home Office are looking at. Is the organisation genuine and operating lawfully in the UK? Can it offer genuine vacancies which meet the skilled worker route? Does it have the HR resources in place to comply with their sponsor licence duties? Is it honest, dependable and reliable? And does to be satisfied it doesn't represent a threat to immigration control? Really just to wrap all that up and explain the purpose of those tests. The Home Office are granting a licence to a third-party organisation which enables them to sponsor overseas nationals or nationals in the UK who require a visa. The Home Office therefore wishes to be satisfied and undertake due diligence that this organisation can be trusted to use that licence properly. If we look at the HR, having relevant HR resources in place, once a licence is granted and a business starts to sponsor skilled workers, the organisation is essentially the custodian, if you like, of the skilled worker. The visa's only been granted for the purpose of working at that organisation in a specific role at a certain location. So the Home Office wants to be satisfied that there's relevant resources to properly monitor those skilled workers who've only been given a visa for that reason. And if there's any issues in respect of their employment, in respect of lack of attendance, changing location, that all of that is being adequately reported to the Home Office in order that immigration control can be properly maintained. Sponsor licence granted, now valid indefinitely. Management of the licence is conducted through an online portal called the Sponsor Management System. It's through the online portal that a licence holder firstly obtains the crucial certificate of sponsorship, which in turn is passed to the potential employee or current employee to apply for the visa. And the portal is also used to report crucial information relevant to either the skilled worker or relevant changes to the organisation. For example, it could be a restructuring of the organisation which affects its ultimate ownership, that requires to be reported. It could be addition of new branch locations where skilled workers are going to be based, it needs to be reported. All communication with the Home Office is conducted through the portal. And finally, just no maximum limit on number of skilled workers you can sponsor when having a licence. Now to the general salary requirements for skilled workers. This slide really sets out the basic calculation. There's a general salary threshold that must be met for each and every skilled worker occupation. But additionally, there's a specific going rate that's assigned to each occupation, and that's based on ONS earnings data. And the calculations, the skilled worker must be paid, or their pay must meet or exceed the higher of the general salary threshold or the going rate for the specific occupation. So simply, if the general salary threshold is higher than the specific going rate of the occupation, the skilled worker must be paid the general salary threshold. If the general salary threshold is lower than the going rate, then the going rate trumps and it must be paid. So how the significant changes. Prior to the 4th of April, a skilled worker's pay had to meet or exceed the higher of the general salary threshold, which was 26,200, or the going rate for each occupation. And until prior to the 4th of April, that was based on the 25th percentile of earnings for each occupation and based on 2021 ONS earnings data. In December, it was very highly reported. Net migration came out 745,000. Significant element of that net migration was considered to be legal migration, not the illegal migration that probably takes the headlines most often. And the government's reaction to that was we need to reduce legal migration. And the obvious go-to for the government seemed to be let's make a significant hike to the minimum salaries for the skilled worker visa route, and hopefully that will at least reduce migration on that route. These increases took effect on the 4th of April. So now we have a parallel system, but we can take it for any sponsor license holder seeking to sponsor someone from 4th of April. The salary now must meet or exceed the new general salary threshold 38,700. So that's a rise from 26,200 to 38,700, a rise of 46%. And or they must meet the going rate. The going rate now pegged to the 50th percentile of earnings from 2023 ONS earnings data. For those sponsor license holders who already have skilled workers, it's a less significant hike. If you have a skilled worker and they are applying to extend their visa or applying to settle after 4th of April, they must meet a lower general salary threshold of 29,000. So a rise from 26,200, but not as significant. Or they must meet the going rate for the occupation pegged to the 25th percentile of earnings from 2023 data. To look to accountancy roles, now the most obvious one is chartered and certified accountants that's found on the skilled worker list. It is accepted by the Home Office that, albeit the title is chartered and certified, that category code includes individuals in training towards qualification. So trainee accountants, trainee auditors are sponsorable, if you like, under that occupation. So here's the new rates. For skilled workers with visas granted before the 4th of April, they presently must be paid. So if you have an existing skilled worker under that category code, they must presently be paid 31,300, and that's set at the 25th percentile of the 2021 earnings data. For pre-4th of April skilled workers, so for that first category, when they're applying to extend or settle, they'll be subject to the lesser increase and need to be paid a minimum of 33,900, that going rate being set at the 25th percentile of the 2023 data. And then there's the significant hike, which is any new skilled worker from 4th April onwards must be paid a minimum of 46,800, and that is because it's now set at the 50th percentile of earnings of 2023 ONS data. So if you look at what currently an employee or skilled work accountancies who have a sponsor license have been recruiting skilled workers on 31.3, now looking at a 46.80 as the general minimum salary. So so that's the general minimum, and then there's when a skilled worker can be paid less, and that's based on the individual having what the Home Office calls specific attributes. And the three main attributes are when an individual has a PhD relevant to the skilled worker occupation, they can be paid 90% of the going rate, or 34,830 as a general salary threshold, or individuals with a PhD in a STEM subject, 80% of the going rate. Those two, I think, probably likely less significant to the accountancy sector. The third attribute is the one likely of most interest, and that is when the individual can qualify as a new entrant to the skilled worker route, and they can be paid 70% of the going rate, or 30,960, whichever is the higher. So how the new entrant works: individuals qualify as new entrants if they are under 26, any individual who has a student or graduate visa when they apply for the skilled worker visa, or any individual who will be working towards a recognised professional qualification in a UK regulated profession. That of course includes accountants and auditors. The maximum period an individual can qualify as a new entrant is 4 years. And then it breaks down into categories. Student visa holders and individuals working towards a recognised professional qualification qualify as new entrants for 4 years. But if you're a graduate, if it's a graduate visa holder, they're only entitled to be a new entrant on the skilled worker route for a period of 2 years. Minimum salaries for accountants as a new entrant. So for skilled workers who have a visa before the 4th of April, when they apply to extend as a new entrant, you need to be paid a minimum of 23,730. Now, I put that there because that is what they need to be paid. The reality is very, you're unlikely to require to be extending for a new entrant, because it's likely that they've already had their period as a new entrant. The more relevant one is for those that are applying after the 4th of April, who are subject to the new 38.7 or the 46,800 for the accountancy position. As a new entrant, they can be paid 32,760, and that's the one that will be significant. And so they can either be paid that for a period of 2 years or 4 years, depending on their new entrant status. And then, however, as you all know, a skilled worker can't reach settlement until 5 years. It's only at the point of settlement after 5 years that they no longer require sponsorship. So if you're looking at a new entrant, there is the cliff edge where after 2 years or 4 years, they no longer qualify. And then you're looking at the significant salary hike. So if it's a pre-4th of April skilled worker, they're looking at a salary hike up to 33,900 to meet the minimum. Not as significant as the post-4th of April, who are looking at a salary hike up to 46,800. As Dawn alluded to, reported last week, Financial Times, City AM, HSBC, Deloitte have withdrawn offers to graduate holders as cannot meet the increased salary thresholds. It was pretty light on detail what was reported. It wasn't reported whether they had fully exercised. The new entrant issue was simply not dealt with. But I think there is no sugarcoating what has occurred since the 4th of April. There has been significant increases to the general minimum salary for the accountancy roles. Points to note, if there's any chinks of light, I would just highlight, which might not be known for student visa holders. Ordinarily, for all skilled workers, an immigration skills charge requires to be paid by the employer. It must be paid in full at the outset, although it pertains to each year of the visa. The skills charge is $364 per year. If it's a small sponsor, that's a sponsor that qualifies under the small companies regime, or it's £1,000 charge per year if it's a large sponsor, does not qualify under the small companies regime. Crucially, student visa holders, if they're switching into the skilled worker route, they do not pay the immigration skills charge, and that is either at the point of their first application or a subsequent extension. So if you look at a skilled worker that you are thinking of sponsoring, new entrant, 4 years, no immigration skills charge, then they would require to apply further at the end of the 4 years, no longer a new entrant. One saving is the immigration skills charge. So I do think it's worth bearing in mind, and it's worth bearing in mind in terms of strategizing recruitment. If there's university milk rounds and you're speaking to student visa holders, I think the tendency in the past was they switch onto the graduate visa. That means they're not eligible for sponsor. They don't need to be sponsored for 2 years, but there's certainly a cost saving in for a company of a student visa holder switching over directly to the skilled worker visa. Other visa categories, I think this is my last slide, is just to be aware, the requirement for sponsorship of skilled workers, it arises for students and graduates as they are on fixed visa periods beyond which they can't extend. You need to keep in mind, I think, with the tightening of the skilled worker route, keep in mind other potential recruits from other visa routes. I highlight, for example, the partner visa. This may become a more utilised route especially for student and graduate visas, because they may understand with a partner visa, they have an unrestricted right to work. There's no minimum salaries that apply, and that will make them more attractive to future employers. There's also a number of dependent visas that also include unrestricted rights to work. And this really brings back to knowing your right to work checks. Obviously, each employer must know right to work checks from a liability issue. But I think it's also important going forward to fully understand all the potential visa categories that are coming in front of you as an employer, because it may be recruits have another visa or future visa options that can establish a right to work indefinitely, or which can lead to indefinite status without you requiring to sponsor and be subject to any minimum salaries. So I'm afraid the closing thought is, for a already busy HR professional, might need to be more keenly aware of all the different forms of immigration status that can maybe be relied upon for establishing a right to work. I think that is my last slide. Yes, it is.
Mark, thanks very much for that. Absolutely fascinating, and I know the whole immigration issue is a real live issue for those in the profession. As you say, you mentioned the reports earlier on last week around graduate placements being rescinded, and the offers of training contracts and such like, and that's certainly something I guess we are hearing through our student education side of things, that the increase in the salary levels was going to start to cause some issues with that. I mean, I guess I think the profession is struggling with talent and recruitment. So immigration from other countries is something that's helpful to us to try and plug those gaps. I guess recently we've entered into agreements with Australia, New Zealand, etc. In terms of mutual recognition of audit qualifications. So perhaps it's maybe going to be less of an issue for those that are perhaps already qualified in other countries, and then looking to move to the UK, because I suspect that they might be in that sort of higher level of going rate in any case. So do you think this is really just likely for the accountancy profession in particular to really just affect those that might be coming in as students, as part of those new learners as such? Is that likely to be the case, do you think?
I think you've hit the nail on the head. I mean, if we go back to what prior to the 4th of April general salary threshold of 26.2, or the going rate for accountancy around about 30,000, and it was thought that once a graduate visa holder had spent 2 years on that, probably their salary was going to be, the accountancy firm employer could meet that. But once the government hiked it up to the median salary for the accountancy sector, more than what half of the sector are earning, that's where it really gives the difficulty when you're pulling it back down to the graduate trainee. And that's likewise for the engineering profession as well. Everyone is seeing that as where the tension point is, as opposed to what you highlight, David, which is bringing in an experienced graduate from an overseas jurisdiction, which is now accepted parity of qualification.
And obviously, Mark, as we know, within any of the professions, whether that be legal or accountancy, or as you say, engineering, there are wide variations or grades of staff within that. So that median is taken over that whole range, rather than looking at, I guess from an accountancy profession, the assistant manager or the manager or the partner type levels. It's a median across that whole spectre rather than a specific role within that, is it?
Tragically so, yes, and also which has been highlighted, that's taking all salaries from that position from the UK, where clearly if you look to the London or the South, there'll be significantly higher salaries. And then we have the phenomena of remote working, where I've spoken to many accountancy firms and say we're no longer just competing with our Edinburgh and Glasgow competitor. We're competing with Manchester and London firms that are saying to the graduate, just you sit where you are in Edinburgh, Glasgow, Dundee, etc., and we'll pay you higher. So certainly it has these pressures.
Yeah, and for anyone that is looking to investigate, sponsor licenses and such like, how long does it take for a new employer to obtain a sponsor license? What would be the sort of typical period for that application process?
With a fair wind, I would say normally from instruction, it's about 2 to 3 weeks, I would say, to marshal all the relevant evidence to put together the business case that we're presenting to the Home Office to justify a sponsor license. Once application submitted, the Home Office have an average processing time of 8 weeks. I find they're meeting that slightly less than 8 weeks. And then there's also a priority service that applicant can use, which, if secure, can obtain a decision in 10 working days. Obtaining priority service used to be as rare as hen's teeth. It's become slightly more available of late. So around about, I'd say slightly less than 2 months, or potentially 2 weeks.
And I guess for any employer that's considering recruiting from abroad, are they better to obtain that sponsor license before they start the recruitment process, or do you go through the recruitment process, find your right applicant, and then do the sponsor license, assuming that you've found somebody suitable? Is there a preference, or?
I would certainly say if you've made a decision as a business, this is a recruitment option we're going to avail ourselves of on a strategic basis. Have the license in place and be ready to go, rather than you have given a provisional offer to a employer, a candidate, but you say, but we need to go away and get a license, because you don't know if is there another offer out there of a business that has a license and can issue the certificate to enable the license. So it's just with a very tight market, I would say obtain the license if you think you're definitely going to be using it.
Yep, that's great. Thanks very much. Dawn, just coming to you briefly, because I'm just conscious of our time. Probably just a couple of questions for you. You mentioned obviously around the new provisions coming in. I think it was October this year, around sexual harassment and the employer's duty to that. I guess we typically talk about those sorts of harassment claims and such like tending to be within the employer's organisation, so it's one employee to another type situation. But is that duty also likely to extend to your employer if that sexual harassment comes from clients or customers? How does that work?
Yeah, so technically at the moment, David, the law was going to bring in third-party harassment again, and has stopped short of that in relation to the provisions that are coming in October. However, in a lot of the discussions about the provisions, they've talked about the wording, the duty to prevent harassment in the course of employment, perhaps extending to third-party harassment. And the guidance at this stage for all sorts of HR reasons is in looking at third-party harassment, provide for it. Make sure you take a zero tolerance policy to that as well when you're contracting with your customers, should you have complaints by your employees, as it's something that you could potentially be liable for.
Yep, that's great. And the other aspect I want to just touch on briefly, I guess, was that interesting aspect around John Lewis and their questioning particularly for, I guess, neurodivergent individuals and that sort of adjustment. Do you think we're likely to see employers moving that into other areas of work as well as just the job application? So I'm thinking around, disciplinary procedures or performance reviews, that sort of thing. Is that the sort of thing where employers should be perhaps giving people advance notifications of the questions that they're going to be asked in those situations as well?
Yeah, I think that's right, David. And I think I'm seeing that more and more now. So, interview processes, giving advance notice of questions, perhaps not on the website as John Lewis have done, but I have seen a lot of employers who may consider that, because they're already giving advance notice of questions and adapting processes from recruitment all the way through the different types of meetings you will go through in your employment, be it performance management meetings or your annual discussions or quarterly reviews, whatever it is that you have, just some advance notice of what's going to be discussed so individuals can prepare as a basic adjustment. So yeah, we're seeing a lot of that now, which is producing positive results and making those meetings more productive.
Yeah, that's great. Well, as I say, unfortunately, we are out of time. I think we could have a lot more to discuss in this area, because, as I say, it touches on every area of business. So, Dawn, Mark, thanks very much for your presentation just now.
Thank you.
Thank you.
As I say, please remember, for all the latest information across ICAS and any other technical information, you can keep up to date with everything on icas.com, and you can obviously access technical support through the ICAS Technical Help Desk. Shortly, we will be launching a poll. It would be great if you could leave us a rating for today's webinar. So please do that. And while you're doing that, I'll also just quickly touch upon what's coming up, because we do have a range of future webinars coming up. Next Wednesday, I think it is, 29th of May, we're going to be touching on tax issues on loans and dividends and everything that you need to know. I'll be back with Chris Campbell and Justine Ricomini from the ICAS tax team when we're going to be looking at all those sorts of issues. Join us as we cover a range of issues, including Section 455 tax issues on overdrawn loans to participators, connected party late interest rules, requirement to complete Form CT61 on interest paid on loans, and a whole range of other issues, some of which will also touch on employment taxes and benefit in kind rules to loans to employees. And again, continuing on the employee theme, and particularly the right to work, next Thursday, we'll be joining Amicus, where we're going to be looking at employee screening and the lesser knowing essentials. So you can join Jeremy Clark, our Assistant Director of Practice, who will be a panelist on that webinar, looking at all things employee screening. And do also please, if you've not already done so, sign up to the ICAS Practice Conference, which is an in-person event on the 5th of June in Edinburgh, when we are bringing together a panel of experts to explore the challenges facing accountancy practices and how to overcome them. And we will be touching upon employment issues and rights to retain, and also Gen Z as part of that. So we've got a theme of employee-related issues in the coming weeks. So as I say, you can sign up to all of those events at icas.com/events. It does only leave me to once again thank Dawn and Mark for your excellent insight, and of course you, the audience, for joining us on this webinar today. I do hope that this webinar has been helpful to you. So until the next time, thank you very much and goodbye.